Parviz Jarabi, attorney at law. I've been practicing for over 20 years. Our office is located by San Francisco Airport, specializing in employment law. Today's topic, unlawful deductions law in California. Under California law, your employers are not allowed to make deductions from your wages except under certain conditions. California labor laws have strict rules to protect employees from unfair wage deductions. Your employers are not authorized to take back money from your paycheck, even if your employers made an overpayment to you in a previous paycheck, or you made a mistake that cost your employers money. There are some exceptions to the rule, but first, let's review which California wage deductions are illegal. In California, your employers cannot deduct any portion of your wages for any of the following reasons: to cover the cost of your work uniform, to make up for an overpayment of wages made in error in a prior pay period, to cover financial losses to the employer caused by an employee, such as cash shortage, breakage, or stolen equipment, unless the loss was due to an employee's willful act or gross negligence. To cover the cost of business expenses the employee incurred through working. To take any portion of the employee's tips. To cover the cost of company property that is damaged by an employee unless the damage was caused by an employee's gross negligence or a willful act. To cover the cost of a bond of an employee if the employer requires the employee be bonded. To cover the cost of the photograph of the employee if the employer requires a photograph of the employee. To cover the cost of physical or medical examinations required by the employer. To penalize or discipline the employee. With respect to tips, your employers can require you to share your tips, also called tip pooling, with your coworkers who are involved in providing services to customers, as long as no portion of the tips goes to a supervisor, manager, or owner. While California law forbids many forms of wage deductions, there are several deductions that are legal or legally required. In California, your employee can lawfully take portions of your pay for the following purposes: federal or state income tax, unemployment, state disability insurance, and paid family leave tax, Medicare, and Social Security. Following the court orders to fulfill garnishments or child support on your wages up to a certain statutory maximum amounts. To make deductions that you expressly authorize in writing for healthcare dues, insurance premiums, or other purposes, as long as the money taken is not rebates or refunds that reduce your wages below the minimum wage. To make deductions that you expressly authorize in writing for payments on a loan your employer gave you, as long as it's not the last paycheck, does not reduce the wages to below the amount required by a wage agreement, collective bargaining agreement, or a statute, and is not more than the payment amount you agreed to be deducted. This means balloon payment on a loan is not allowed. To dock your pay for any late arrivals to work, as long as the deductions is in proportion to the amount of working time you missed or a minimum of 30 minutes, or to make deductions authorized by a wage agreement or collective bargaining agreement to cover health and welfare or pension payments. The above listed deductions are legal, but you should still inspect your paychecks and consult an employment attorney if you notice discrepancy. Remember, you have the right to review your payroll records So you can demand payroll information from your employer if you do not have it already. If your employer violated California labor law by making illegal deductions, you can file a claim. And if your claim is successful, you can recover your damages, such as your unlawfully deducted wages and penalties. If you have any questions on this topic, please contact my office for free consultation. Please be sure to like and subscribe and turn on your notification.